Welcome, everyone. Letting folks in from the wait room right now. So just give it a moment and we'll be getting started. Welcome. Okay, so welcome to today's webinar. This webinar is about high conflict divorce in Washington State, legal tips and drawing boundaries. And I'll be joined here in a moment by Michelle Dellino with Dellino Family Law Group. Briefly, I'll introduce myself. My name is Melissa Rosenberg, and I'm a therapist here in Seattle, Washington, with a specialty in working with clients who are navigating different stages of the divorce and separation process. I work with clients who are trying to determine whether or not they are looking toward separation, or if they're in the middle of a family law case, or on the other end when they're trying to develop next chapter. I do work with both individuals and couples, and certainly many or most of my clients have been involved in high conflict situations. And so here today, though, as the moderator for this webinar, and the way that it's going to work, I'm going to pass it over to Michelle in a moment to introduce herself and kick it off. And she's going to be delivering a lot of great content about this topic today. And as well as the information that Michelle is relaying to you all, we are also open to taking your questions. And so what we're going to do, the way that you can ask a question while you're on the webinar is one of two ways. You can put it in the chat. If you put it in the chat, it'll just come straight to me and I will pitch it to Michelle and we'll try to get that answered. You can also put it in the Q&A option on the Zoom screen. If you do that, it will show up with your name next to the question unless you mark yourself an anonymous attendee. So that's also an option. Either way, we'll take those questions. We won't be able to answer questions that are too specific to your situation. But if you have more general questions that could be useful and we might be able to answer more generally, then we'll go ahead and take those questions. So with that said, we'll be here for an hour or just under, and we look forward to delivering some great information today. Thanks for being here, and I'll turn it over to Michelle.
Hey, thanks for being here. I'm Michelle Dellino. I am the owner and founding attorney of Dellino Family Law Group. We have offices in Seattle and in Bellevue, and we help clients all over Washington State. I've been practicing family law for about 16 years, so what might be crazy to you is probably somewhat normal to me. And we're talking about high conflict today, so that's a good lead into that. One thing I'll tell you before we start is that I am an attorney, but I'm not your attorney. So nothing that I say here, and even if I am your attorney and you happen to be watching this, nothing that I say here is legal advice. This is information for you to take away. Like Melissa was saying, if you're asking very fact-specific hypothetical questions, this isn't really the place for that. The place for that is a consultation or meeting with an attorney that you've retained so you have privacy and you can actually get legal advice. This is general information. I want to help you out, give you some strategies, give you some tips that you can take away from this, hopefully. And even if you don't have an active case and you're just thinking about a case, this is really helpful as you start to think about moving forward. If you're in the middle of a case, hopefully, you might take something away to kind of help think about structure, strategy, and support as you move forward. So with that said, let's go ahead. I will stop at a few different times to take any questions that might come up. Melissa told you how to best send her questions if you want to keep them private or anonymous. Also, too, if you have to get off the webinar at any given time, these webinars are posted later, and you can link to them from our webpage. They're posted on our YouTube channel. There's also other content there that you can view, and we'll go from there. Okay, so if you're here, you're either in a high conflict family law case, or you're worried you're going to be, or you're not sure if you are, and you're wondering, what can I really do? And I like to acknowledge right away for you that this is a very difficult process emotionally and financially. And there's no way to say necessarily how things are going to go. So I'd love you to watch this webinar and I'd love to be able to tell you, hey, guess what? I can tell you exactly what's going to happen in your high conflict case. And that's just not the case, and that's not realistic. It's difficult, it's tough, it's stressful, and you're going to have to deal with a lot of ups and downs financially and emotionally in any high conflict case. So you need to know that right off the bat. I apologize, I have a little bit of a cold today, so just bear with me. But what I wanted to tell you too to start is that what is an attorney's role in a high conflict case? Like, we're not miracle workers. We can only deal with the cards that we have, in our deck to play with here. So we have certain roles, though, that you need to know. We're here to protect you. We're here to try to minimize harm to you, and we're here to try to guide you through a structured legal process that can sometimes be very uncertain. We're not here to promise you an outcome. We're not here to control the other party's behavior, because we can't control the other party's behavior in a high conflict case. We can control our strategy and your responses. That's what we can do from an attorney perspective, no matter who it is. Or if you have an attorney that's trying to create the conflict, which is not something that I would do, and not something that any attorney I would really respect would do, but if someone is trying to create conflict, that's a different story. So I'm not talking about attorneys that are trying to create conflict. I'm talking about ethical, competent representation that's not just going to tell you what you want to hear, that's going to tell you, we're here to try to guide you through the process and protect you, but we can't promise you anything, and we're not want to have a client, if they ever come and say, I want to make this person's life a living hell, I'm not going to do that. Sure, we'll protect you and make things, as to your advantage as we can, but I'm not here to try and ruin other people or file things that don't have any merit. And most attorneys aren't here to do that either. So just keep that in mind. We can't control what happens, but we can control your strategy and your responses. Okay. So understanding the high conflict divorce, that's usually the best place to start. What is it? Like, how do I know if I'm in a high conflict case? Because I'll tell you what, everybody likes to say, one, their spouse is a narcissist, and two, they have a high conflict case. Like, I think probably 90% of people say that. And the other 10% says, oh, we just want to get along. And one party usually thinks that and the other party doesn't. So, but everybody thinks their spouse is a narcissist. And Melissa can tell you, as a mental health professional, that that's actually a diagnosis. It's not, people can have narcissistic tendencies or behaviors, but you need to understand when you're thinking about a high conflict divorce. You'll also hear terms like covert narcissist, which is a very popular one on the internet right now. And I'm not saying that narcissistic traits and narcissism and covert narcissism aren't real things, because they are, but you can be in a high conflict case with someone that's not a narcissist. And just because you might be in a high conflict case doesn't mean that person is a defined narcissist. When you start using that word, and it can be used sometimes, but if you start using that word, I'm going to tell you this right now, a lot of attorneys and a lot of courts, they just tune out because they hear it all the time and it means nothing and it sounds very dramatic. So it's better to actually, when you're thinking about high conflict, define what the high conflict is and define what the traits are. Why don't you say that, Melissa? Like, not everybody's a narcissist.
Yeah, I mean, certainly if you're in a high conflict case with somebody, they probably do just have narcissistic traits or tendencies, meaning they're manipulative, they're entitled, they're, toxic to communicate with. Focus on the things, those characteristics, those traits when you're trying to figure out how to contend with them. And it can be helpful sometimes to understand under that lens of narcissism, but like Michelle's saying, as far as somebody actually qualifying to meet the criteria for a narcissistic personality disorder, it's a lot more rare that's the actual case. And I don't think it necessarily even matters. I think it's more just around, hey, what are you dealing with in the situation? What kinds of behaviors are you faced with? And that's going to help you figure out what you need to do in order to do that in as healthy a way as you possibly can to take care of yourself and to communicate effectively.
Yeah, absolutely. So defining features. Maybe they're a narcissist, maybe they have narcissistic traits. Hard to say. One thing you can say for sure is one or both parties probably display extreme hostility, manipulation, like Melissa said, they probably are manipulative, or refusal to compromise. Like, those are kind of the hallmarks of one or both of the parties in the case. And it's true that, like, you might both have extreme hostility. Maybe you didn't go into the case feeling really hostile, but maybe you do now because of how things have gone. So that's normal. Other defining features of high conflict divorce or family law case include frequent litigation, going to court over a lot of things, accusations and disputes over parenting and finances, like accusations about people that may or may not be true. You may or may not be believed because everybody's slinging a lot of mud, everybody's telling a different story. There's lots of litigation. Parties probably aren't communicating cooperatively about anything. So those are defining features: manipulation, hostility, refusal to compromise, frequent litigation, slinging mud, disputes over parenting, disputes over money, disputes over like every little thing. So those are high conflict features. Common behavior from high conflict individuals is what Melissa was talking about. They might manipulate, they probably escalate, and they try to provoke you. They probably try to misuse the legal system at certain times. Certain people in a high conflict case will file excessive motions, they'll abuse discovery, they'll do things like that. Sometimes they'll have an attorney that enables that and does it, and they don't really stop until they get ordered to pay attorney fees. Other times, they're doing it on their own. You're represented and they're not, because you want a level of protection, and they're doing things and filing things wrong and filing things they shouldn't file. And they're like, well, I didn't know, I didn't have an attorney. And they're trying to do that. So there's different levels of common behaviors when it comes to litigation, but they are probably definitely trying to escalate and provoke things with you. And sometimes they even involve children in conflict in a high conflict case. And that's really kind of the sad part and the worst part, because if you're in a case with another individual, unfortunately, you're in it and you were in a relationship with them at some point, and you're an adult and you got to choose to be in this relationship with them, and now you're trying to choose to leave it. But children don't get a choice. And so when children get put in the middle and pulled in different directions and involved in the conflict, it's really unfortunate, and you want to do everything you can to shield them from that. And courts don't look kindly on children being drawn into the conflict or being made to be pawns or subject to witnessing abuse or anything like that. So why does it even matter if you have a high conflict case, like legally? What's the deal? Well, it increased costs, it increased delays in finalizing anything, and it's a high emotional toll. I think that's one of the biggest issues. I mean, costs, delays in getting things done, and emotional toll, that all sounds pretty bad, right? And you have to find a way to make it through it. So how do you make it through it? Well, you are not going to have a smooth ride. Like, there's nothing I can say to you that's going to say this is going to make everything really easy. This is about awareness, and it's about realizing that you kind of need strategic management and awareness of your situation. You really do. And sometimes you can make things better that way by being prepared and by thinking ahead, and other times you can't, because no matter what you do, this person is not going to be reasonable. You can't be reasonable with someone that's unreasonable, but you can try and control your reactions and the strategy. So that's really what it's about. Again, if you have an attorney in a high conflict divorce, that's probably a good thing. It gives you a buffer. It gives you someone that knows what they're doing to help you navigate the situation. Some attorneys won't work on high conflict cases because it's not what they do. They don't personally deal well with it, and it adds a layer of stress or complexity that they don't want. Many attorneys will deal with it. So it just depends. Finding somebody, though, that understand what that means and is not freaked out by dealing with these kind of individuals or attorneys is a good way to go. Like I said in the beginning, a reminder, an attorney's here to protect your rights and ensure to try to get you a good outcome, but they can't guarantee an outcome. Sometimes a court will do something that you would never expect, and that's crazy. Sometimes that's good and sometimes it's not, but we're not the court, so we don't get to call the shots. All we can do is try to put you in the best possible position. One thing an attorney can do is serve as a shield, a buffer between the client and the other party to reduce direct conflict and contact. If you're a represented party, the other party can be told they have to go through counsel, even if there's no protection order in place, to deal with you. They don't get to call you, they don't get to email you, they don't get to text you, and sometimes that's really necessary. There's other ways also to lessen that contact through tools if you have children, like Our Family Wizard or Talking Parents or things like that. If you have protection order or restraining order, that's different. But it can also just be a very contentious situation where communication about legal issues needs to go through counsel. So attorneys are here to be a shield for that and a filter. Strategy. Attorneys are here to help you develop a strategy. Sometimes you can be proactive, sometimes you have to be reactive, but either way, you need to know where you're going and you need to have a way to try to get there. And if things don't go as you like, you have to be able to pivot and be like, okay, what are our options now, right? And you need a guide for that. And attorneys are here to educate or help you understand the process, likely outcomes, and realistic expectations. No attorney's doing you a favor if they're not realistic with you. I mean, I don't really actually know any good attorneys that are not realistic, because, you know, as much as we would like to control every situation, and I'm stressing this a lot in this topic, because in a high conflict situation, flip a coin. You don't know what's going to happen, right? We just try to strategize. So let's talk about that then. Key tools and strategies. So if you're dealing with parenting plans and custody, here's some tips for you. The more detailed, structured parenting plan to reduce ambiguity, the better chance you're going to have at either co-parenting or parallel parenting with that high conflict person. Sometimes you need no ambiguity in your plan. You need to be very clear about everything down to the detail of how the exchange is going to take place. If there's Every little detail. You don't want any ambiguity in your plan. You don't want anything that's not contemplated. You want to have a very clear, not just dispute resolution process, like we're going to mediation or we're going to arbitration, but how decisions are even made and communicated between one party and the other. You want a response time in there for that. There's all kinds of detail that you want. So the more detailed, structured plan that you have, the better it's going to be in a high conflict situation. Um, you might need to incorporate additional dispute resolution mechanisms. A lot of times, high conflict cases, especially when they're finalized or there's a modification, they might need they might need a parenting coordinator, which is kind of a referee and someone that's on all communication. Sometimes that's necessary. One party might be ordered to go to co-parenting counseling. I'm sorry, to parent counseling. Very rarely would you ever have to go to co-parent counseling with the other party. That's more of a voluntary thing, and you wouldn't do that in a high conflict case. But parenting coordinators are very common in high conflict cases, and parent coaching can be ordered by the court, maybe for one party or the other, or agreed to in different settings. So, parenting plan, another thing, you need to advocate for limitations on unnecessary communication to protect children and you. So, that means not having a parenting plan that's super vague that says parents in a high conflict situation, parent A can call parent B, can call the child at parent B's house as much as they want, and it just leaves it super vague. No, sometimes you need to say there's a scheduled call at this time. Parent A shall have, up to one FaceTime call during the other time with the child's time with parent B. Okay, well, when that call is going to be, and make sure it's one, not just liberal contact. Maybe liberal contact makes sense in some cases, but it generally doesn't in a high conflict case. A lot of the time, there's just no contact absent emergencies for kids when they're with the other parent because that level of communication isn't necessary. High conflict cases also, it also is going to depend on the age appropriateness for your child, but sometimes fewer exchanges is better. Like if there's no reason for restriction on one of the parents, no DV or anything like that, but you don't want a plan where you don't want, unless you have really young kids, and even then, maybe not, like a 2-2-3 plan where you're having a ton of different exchanges and you're having to see this person all the time. Or if you do have exchanges, you very often want to have them with school drop-offs so you aren't having face-to-face contact, things like that. Sometimes you'll even need supervised exchanges if it's that kind of a situation. And there are supervisors that will supervise exchanges. So all of those things in parenting plans can help protect you and your children. I will pause to see if there are any questions before I move on to talk about other things.
Yes, there are a couple of questions. Actually, I want to use it just for a quick moment before I jump into the question to just also mention that if you're in a case with a high conflict, soon to be former spouse, making sure that you have your support network in place is really, really important. It's important for anyone who's going through separation, but especially if it's going to be a high conflict situation, you got to make sure that you can approach conversations with your attorney and reading your legal documents and they may be saying negative things about you that you now have to read, and that can be really, really hard. Or you might have to tell your story of the toxicity in your relationship or potential abuse repeatedly, and that's really, really hard. And so making sure that you have adequate emotional support to manage this time cannot be more essential. Working with a therapist throughout the process, I think, in some cases should be mandatory because it's so important and so useful. Also making sure that you have healthy social supports and people in your life who really understand you, who you can talk to when you need them. So
Yeah.
just putting that plug in there, but let me go over to a couple of questions that have come in.
Really
One,
quick on that too,
yeah,
before you
yeah.
do. I just want to say from the attorney perspective, I have had cases where a client is obviously in so much distress that I don't want to work with them unless they have a therapist. And the reason why is not because there's anything wrong with them or because I think they don't need, an attorney, but it's because if you're treating an attorney like a therapist, number one, our hourly rate is way too high for that. Like, we're here to give you legal advice. It's not that I don't want to hear what's going on, because I do. I really do. But I want to refocus you on what I can help you with. I can't help you process it. I can't help you deal with the trauma that this person is causing you. I can give you some good coping tools, which I'm trying to do today, but it's very different than working with a therapist. It's going to help reduce your costs because you have that outside person that's also going to help you be prepared and more present to interact with your attorney and deal with stressful situations. I can't stress that enough. Other times, and this is just an aside, you might be in a situation where the other party's in court and questioning your mental health and saying you're, a mess and you're a bad parent or whatever. And if you can kind of be like, well, I'm in therapy, what about you? It actually looks good.
Mhm.
Some people will say, well, is it going to look bad that I'm in therapy? No, it's a good thing. It means you're taking care of your health so you can be present for
Mhm.
yourself and for your child. So don't ever think it's a bad thing. And I really think the clients that have a therapist, they spend less on extra costs. That's just kind of the way it is.
Yeah,
So go.
yeah, absolutely. Yeah, well, one question is, if a spouse has been assessed to have a mental health issue, borderline personality disorder, that is another diagnosis that comes up in high conflict.
Yeah.
Can you address that? What is to be done from a legal perspective if a spouse has a mental health issue?
Well, I'm gonna make really clear about this. A lot of people have what you would call a mental health issue. I mean, a lot of people are in therapy, a lot of people have some kind of diagnosis, a lot of people are depressed, a lot of people have anxiety. It doesn't mean that you can't parent. If you have a borderline personality or other kinds of diagnoses, those are more likely that there is a nexus between your mental health issue and your parenting. But there has to be a nexus, just like with alcohol. Or substance abuse. You could be a recovering alcoholic and doesn't matter because there's no nexus between that and your parenting. You could even be someone that drinks, but that doesn't mean there's anything wrong with you being a parent, right? You could be someone that's been diagnosed with depression and it doesn't mean there's going to be restrictions against you or you can't parent. But if there is a nexus between that person's behavior and their parenting, then that could be a basis for restrictions in their parenting plan. And when I talk about restrictions, and you might hear the buzzword 191 restrictions, that refers to section of Title 26 that spells out restrictions in a parenting plan. And restrictions just means a basis to restrict time between a parent and a child. In the parenting plan, a restriction could be a restriction on decision making, which is also in a parenting plan and a high area for conflict. Restriction could mean that a parent has to comply with certain treatment or therapies or other things they have to do or supervised visitation. So when we're talking about a restriction, if this person has a mental health issue and there's a nexus between that and their parenting, what you want to do is talk to an attorney and determine, is this rising to the level of being something where we need to seek restrictions in a parenting plan, or we need to seek some kind of compliance for this person to make sure they're taking care of their mental health so they can parent. If you don't have kids, frankly, the best advice I can give you is to not have direct contact with this person because you're not going to be having a relationship with them going forward. Have your contact be through attorneys and cut ties as much as you can, because dealing with someone that has mental health issues that's trying to draw you into their drama in the middle of divorce is a recipe for disaster.
Thank you.
I'll take one more.
Another question here. Is the term high conflict a legal term the court recognizes or assigns? How do you know if your case is deemed high conflict?
No,
Yeah.
everybody's gonna say their case is high conflict. So no, it's not a legal term. I mean, it's something that is used in the legal world. People say high conflict divorce. I mean, look it up. There's a million things about it. It's a real thing, but it's not like you're going to court and they're like stamping, this case is high conflict, this case is not. No,
Mhm.
there's nothing like that. And if you have, it's kind of like I was saying earlier about the word high conflict or narcissist or whatever. If you're saying those things, you need to back it up with like what the behavior is. The court's way more concerned about what's happened here, what's the behavior here, than if someone just says this person's a high conflict individual. Great, what are they doing that's high conflict? Or I have a case that's been going on off and on since 2017. It's high conflict. And the court at the beginning of like every hearing will look at the docket and there's hundreds and hundreds of things in there. The court will be obviously like, okay, these parties have, sometimes someone will say, parties have, this case has been very high conflict. These parties have a long history of litigation. And most cases aren't like that, but this is just this case where it's high conflict. And that's very obvious. And so the court might like acknowledge that and just be like, great, but they might do that when they're looking at the docket and thinking, okay, these people have a lot to talk about, so we'll wait till the end of the case. But there's not like a stamp that's put on your case. So
Thanks.
I'll take more, but I want to talk really briefly about communication protocols. So, because I want to make sure I get this out there. So, one strategy that you can use that courts will order this in a case that they might think is high conflict or just where there's problems going on is to establish a structured platform communication with the other party. And sometimes in protection order cases or restraining order cases where you can't have contact with the other party, it will say except for parenting communication in one of these platforms. So the structured platforms like Our Family Wizard or Talking Parents are kind of the most popular ones. Our Family Wizard's a little better. Neither one of them are amazing. I feel like someone should come out with a better one. But Our Family Wizard does have a shared calendar. So does Talking Parents, or it used to anyway. I think it does. I prefer Our Family Wizard though, because it also has the feature where a really common thing in a high conflict case is someone to be like, oh, I didn't get your email. I didn't see your text or whatever. It didn't go through. Well, in Our Family Wizard, if you send a message, when the other person views it, it tells you that it's been viewed. So no one can say they didn't see it. Or if you know someone's not logging in and looking at it, and they're supposed to be because it says in the parenting plan they need to be checking Our Family Wizard and respond within 2 days, you're going to know that. So it's a really good way to do it. It also has a tone meter. So if you're kind of sounding like a jerk or your tone is bad, it will tell you if you turn that on. And courts are very familiar with seeing Our Family Wizard. Attorneys can get Our Family Wizard access to see the communication, so you're not having to forward your attorney every communication. So using a platform like that, it also stops your phone from blowing up with text from this person. You don't get like anxiety when you look at your email. It allows you to kind of move on with your life and keep this communication in one spot. So it's a really good thing. I also like to talk to clients about BIF. I don't know if you've ever heard that. My tone and what I think is a good tone to take in a lot of cases, including high conflict ones, is to be fair, firm, and friendly. Be fair about what's going on. Be firm about what your boundaries are and what you want, and be friendly until there's a reason not to be. And then when you're not friendly, you might not be, you're not making it personal, but maybe you tone down being friendly, but try to be friendly because the better that you present yourself in representation, the more respect you're going to get from the court. Everyone's like, oh, I want a bulldog attorney. Well, bulldog attorney gets like locked in the pound. Like courts don't like that. Nobody likes that. The only thing sometimes that people like is they see some attorney like standing up there and like yelling and pounding on the table. Well, everybody stopped listening to them and lost respect for them the minute that they did that. Maybe it made you feel better, but you're not going to get what you want. You want someone that's fair, firm, and friendly. And knows how to advocate for you, not create a show, because people create a show when they don't have anything to talk about. So that's something for you to know. And doesn't mean that you can't have aggressive representation, but someone that is what people call a bulldog. And when you say that to someone, it makes attorneys not want to represent you. So don't say that if you're thinking about that. But the thing I like to tell clients is you, on the other side of that coin, should think about BIF. Now, BIF, B-I-F-F. Bill Eddy, E-D-D-Y, wrote a very good book about this, and he has some really good stuff out there. BIF stands for brief, informative, friendly, and firm. So it's kind of the fair, firm, and friendly in your communication. In your communications to a high conflict person, be brief. No extra commentary. Be informative. We will meet you at the exchange location at 9 a.m. Be friendly. Thanks. And be firm. 9 a.m., not 9:15, not whatever, or if someone says something to you that's super inflammatory and terrible, you'll either ignore it and just respond to the substantive part, or you'll respond. And what I like to say to people who are high conflict and lie and do things like that is I like to say this, that's not true, period. That's it. That's not true. We'll meet you at 9 p.m. That's not true. I was there at 9 p.m. Whatever. And then move on. That's it. And don't say anything else. So be brief, informative, friendly, and firm. Melissa?
I love that so much. And I think that it falls under the category of setting appropriate boundaries, right, for your communication, because you're going to need to figure out what your boundaries are. It's going to be a little bit different for everyone. But when you do that and you decline to participate in the toxic spiral that they're trying to pull you into, you're holding a boundary that's really important for your own well-being and probably also for your legal case, right? So just don't get caught into it. Likely, if you're dealing with somebody like this, you've been through it. You've been through the spirals. You know what these toxic loops are, and it's not serving you, right? So um please go ahead and do consider these boundaries really important and what other ones you need to set. And sometimes when you really can't communicate them with them much at all, utilize your attorney even more. Hey, we're not getting anywhere here.
Yeah.
Help me figure out this thing that might seem really small but I can't communicate with them. Use
Totally.
your attorney, use the communication apps, and set your boundaries.
Yeah, that's exactly it. It's all about boundaries. And another thing on communication protocols I like to stress is It's okay to set a curfew on when you're going to deal with these things. Like you've had a busy day, you've been at work, you're in the evening, you're looking at this stuff on our Family Wizard. Just tell yourself, I've got a curfew on looking at any of this, and it's 7 p.m. After that, I'm going to focus on, anything but this. So absent like some kind of an emergency about my kid, I'm setting a curfew on dealing with these issues for the end of the day. Do things like that. And then document interactions for potential evidentiary use later, which is unfortunate you need to do that, but in a high conflict case you do. Our Family Wizard is a great way to document. If you don't have kids and you're in a high conflict case and you have to communicate with the other party, save your text messages and emails, and don't write anything that you wouldn't want to be read in court or used as an exhibit. Always be fair, firm, and friendly in your communications like someone is watching, because the odds are someone will be. And then if they respond and it's super whatever, then you have that to use. I mean, that's just the way it is. I can't tell you how much that happens in cases. So, um, before I talk about court involvement, do you want me to take another question or two?
I think we're okay right now.
Good. All right, perfect. Court involvement and protective measures. So this is what I want you to think about. So there is what we call motion practice. So that means you go to the court and you ask for a motion on something and you ask them to do something for you. And when does this happen? This can happen for temporary orders. And what are temporary orders? They happen a lot in high conflict cases, or regular cases that aren't even high conflict. But temporary orders is when you need a temporary status quo and the parties couldn't come to an agreement on what that was going to look like who's going to stay in the house, who's going to pay how much support, who's going to pay what bills, where the kids are going to live, what's the temporary situation going to be. So you need a temporary issue resolved. And you need to go to court to do that. That often happens as a temporary order. You can get an immediate restraining order, and that means you need to get in and you need to get something issued for you immediately to put a child with you, to get some kind of emergency relief. That's only going to be issued on a temporary basis before a return hearing when the other party has a chance to respond, if there is a chance that irreparable harm will occur if that order is not issued. Otherwise, you got to set a hearing for it. But temporary orders is where a lot of issues are resolved unless you need to get an immediate restraint to hold you over until a later hearing. Protection orders. Protection orders are what you get if you've been a victim of domestic violence, sexual assault. Domestic violence can also include coercive control. It can include a lot of things. And evidentiary issues are somewhat different in protection order cases. And it's unfortunate, but sometimes, the court will deny a protection order when they shouldn't. Sometimes the court will grant one when they shouldn't. You never really know what's going to happen, but it's never a bad idea to seek protection if you need it. So that's something else that you can do. Other court involvement and protective measures. Guardian ad litems or parenting evaluators are very often appointed by the court or agreed on by the parties in a high conflict situation where children are impacted and there's parenting issues and you need somebody else to do an investigation and talk to these people and talk to other people. And then you start to get an idea and you get objective information about this person's behavior, and that factors into recommendations that are made. So guardian ad litems or parenting evaluators, protection orders or restraining orders, temporary orders. These are all things that the court can do in order that can help you. Parenting coordinators, like I talked about earlier, is also unfortunately sometimes necessary and common. And usage, like I was talking about, of Our Family Wizard or Talking Parents can be ordered by the court too. It doesn't have to be agreed upon by the parties. So there we go. Yeah,
We do have a couple of questions if
sure,
it's a good time. Okay.
sure.
Um, we're on the thread of communication we were talking about earlier. This participant's asking, what's the best reaction when the spouse writes long letters of false allegations? They're saying they tend to not respond at all, but they're concerned it could be used in court against them, even even though they're false, even though the allegations are false.
No response is a response. This is what I like to
Mhm.
say. So no response is a response. Or if you have to address something, you can just say, that's not true. And here's the response. And that's it, one line. But no response is a response unless you really have to respond about something. It's not going to be used against you. It's actually better because then they have no mud that you were slinging to put in the court file. It's just, what are they going to say? I sent these crazy emails making allegations and they didn't respond. Oh well.
Mhm.
If they
Mhm.
make allegations against you in a declaration, you do need to respond, and that's different. And that's something your attorney would help you deal with. You do need to respond and say what happened. But if someone's just sending you emails or Our Family Wizard messages and they're just saying stuff that doesn't matter and is inconsequential, no response is a response, and it's totally
Mhm.
okay. I will take more, but I want to talk about financial protections. So it's really important, really, really, really important, that if somebody is engaged in abusive litigation and bringing things, bringing cases and bringing motions that are not have no substance behind them, which most attorneys won't do. They really won't, but some will. And it's important that you ask for attorney fees in those cases. I have many cases over the years where the only thing that really gets bad behavior to stop is when they're paying my client thousands of dollars for what they did for bringing this motion. And there's no guarantee you're going to get attorney fees, but a lot of the time you do. So it's important to do that because it makes somebody think twice. And if someone in a high conflict case, another thing that often happens is somebody's trying to conceal assets or hiding things. So if that's the case, then you don't just start asking for documents informally, you actually propound discovery. You might get a tracing report done if you think money's moved somewhere. You actually back up the allegations you're making. You can't just say this person hid money and did all this stuff. You actually have to do the work to document that and show it. Don't make allegations about someone else's behavior when you're not willing to do what's necessary on your end to show that. So that's something for you to know.
Mhm. Mhm.
Okay. Any more before I move on?
Yeah, this question, I guess it's kind of a timeline question. If you have been, it says if you've been summoned by your partner with a very detailed declaration and parenting plan, how long does it usually take to put together a full response with your own declaration, parenting plan, financials, etc.? So how
You
long
say
does that
summons. I mean, I'm assuming this person brought like a motion and you have to respond. How long does
maybe?
it
Yeah.
take? I mean, it depends. Like, let's just say, for example, in King County, the moving party has 25 pages that they can write for declaration space. That doesn't include exhibits. You get 20 pages to respond. So usually a moving declaration, they're going to save some pages to the end. But if they dropped a 20-page declaration on you with a bunch of stuff to respond to, I mean, I don't know how long it's going to take. Is it
Mhm.
going to how much information are you going to provide? Are you going to provide information, or are we going to have to call you 5 times and get on the phone with you because you didn't send us anything and now we're working at the last minute on it? Like, how the best thing you can do is organize your thoughts in response and then work with your attorney on that draft. How long that's going to take is depending on what the claims are. It could take a couple of hours, it could take many more. It really just depends. The more organized you are, though, the less time it's going to take. The quicker that you
Mhm.
are too in giving us something to work with, the better it is. If you're saying, oh, I'm going to get you this, and then it's like a week later and it's kind of a mess and we're trying to get it in the page limit, that can take time too. And a lot of the time, things that you think are important might not be that important. And now we're at 35 pages and we're trying to prioritize what's important. So it really depends on what their allegations are and what your response is. And also, too, I should say, what evidence you have in response to what they're saying. Because if they're saying all these things and you need to incorporate all these text messages to show that's not what happened, or you need a third party declaration, which sometimes happens, you might need a declaration from someone else to say that's not what happened or what their personal knowledge was. And a note about third party declarations, they can be helpful in some instances, but a lot of the time when they're from friends or family members, they carry little to no weight because those aren't disinterested witnesses. If you have like a therapist or somebody from a school or somebody that's totally neutral and has no dog in the fight and is not somebody's friend or family member, that's a lot more valuable. But sometimes those might need to be incorporated. So it's really hard to say. Are they
Yeah.
financial issues? Are they parenting issues? Like, I don't know. So anyway.
Another process related question. If a temporary order is issued by the court, how long until that order is lifted or reassessed?
Probably not till the case is finalized. It's very unlikely if there's a temporary order that there's going to be another one unless there's a substantial change in circumstances that wasn't contemplated or didn't exist at the time the last order entered. But there's not usually multiple temporary orders. Usually you have temporary orders, you have a status quo, and that's a pretty big thing if you have to go to court for temporary orders. So it's highly likely that that's not going to be changed until you either come to a mediated or agreed settlement or a settlement before a trial court. So.
Okay, thank you.
Okay, so let's talk about managing your expectations in a case like this a little bit. You need to be realistic. Courts are not going to solve personality conflicts. They're only going to solve legal disputes. They're not going to make somebody be a better parent than they are. They're not going to make somebody not be the jerk that they have been for the last number of years. They're not going to solve those issues. They're only going to deal with the legal issues. They're also going to tune out, or a lot of people will be like, the court didn't hear me. They didn't care about all the stuff that he or she did. Well, Washington's a no-fault state and somebody gets to act like a jerk, they're not going to waste time focusing on that because that's not what they're there for. Sometimes you will get a court commissioner or a judge that will tell a litigant your behavior was really bad and you can't keep doing this. I like those moments because it's usually not my client. Sometimes it is, but it's usually not. And it's something that's important because then a litigant gets to hear that, and sometimes it sticks with them. Other times it means nothing to them and they don't care. So it's like they're not, courts aren't wasting a lot of time on that. They're wasting on what they're looking at. What are the issues before me and what can I do about it? So be realistic about what a court can and isn't going to do. Um, a lot of people are like, I want justice. Well, I mean, justice, it never looks the same for two people, frankly. Focus on outcomes, not battles. This is really important. Focus on like prioritizing your children, your financial stability, and your long-term peace. Do not focus on this little battle over whether I get to be the one that takes the kid to the soccer game this weekend. Like you both could go to the soccer game, but if we're really going to fight about who gets to be the one that brings the snack or does this or that, I mean, these are fights that people have and they're focused on the battle of winning this fight. Do not do that. Focus on the overall outcome, prioritizing your kids, your financial stability, and frankly, your harmony. Like you protect your peace. I know that's such a thing that people say now, but it's really true. Protect your peace. Cost awareness. So the financial impact of repeated litigation is high. Like it just is. And yeah, we're attorneys and we get paid to do that work, but we don't enjoy you spending your money that way. I would rather you have I know people don't like believe this or understand it, but I just was at a group last night where I was telling people how to keep your costs low. Do not save us. Do not send us 20 emails in a day. Send us one email that's really important and focus the issues on one email. It's going to cost you less than us being in and out of our inboxes all day responding to all your questions. Like it's not that we don't want to, but it's going to keep your costs low. If there's something that can be resolved without court, we want to find a way to do that, whether it's negotiating through counsel because you have control over the outcome and it's going to cost you a lot less. I would rather that you have money to go to a full day mediation and actually get your case settled than run to court because somebody was late for an exchange and you were mad about it and they violated the parenting plan because they were half an hour late. Like you want to spend $8,000 on that? Okay, like that's not a good usage of your money, you know? So think about the return on investment, but also be aware that if someone's dragging you into court, it's like I said earlier, you have to go if you're responding. And then, you know, you might have an opportunity to seek fees. I can't promise you that you'll get them, but sometimes you will. But pick your own battles. Don't instigate just to try to make somebody's life miserable because money is always better spent elsewhere. But it's expensive. It just is. Nobody puts aside money thinking that they're going to be in this situation. So the more that you can get along, the less that you're going to spend. And sometimes you can't control that. I also think it's important to focus on what I would call your emotional resilience. It's a little bit what Melissa was talking about earlier. I highly recommend therapy in a high conflict situation. I recommend it anyway, but you know, support groups, if there are groups that either meet online or in person that make you feel supported, I highly recommend focusing on those, you know, or just your own social circle. I think it's a really good idea to realize who your support is and who it is not. Don't talk to every single person in the world about your case. Don't post about it on social media. Know who your people to go to that you can trust are and who are not just going to be like, oh, Sally was talking about her divorce again. Here's what she said. You know, don't do that. Like, know who your resources are for support and focus on those people and make sure that you have them. So really, really important. I can take a couple more before I wrap up if you want.
We don't have any more right now. Like you're
Good.
being very
Terrific.
thorough.
Moving right along. I appreciate that. All right.
Oh,
Attorney
sorry. There
client.
is one question about just since this is recorded, can you say again how the video can be watched later?
Yeah, you can go to our website. I think there's a tab called News and Resources, and it'll
Mhm.
take you to our YouTube page, or you can just go right to YouTube and search for us, and you'll be able to see it there. They'll probably post it tomorrow. That's my guess. So, okay. This is really, really important. Your attorney-client partnership, okay? You're not going to love working with an attorney, and they're probably not going to love working with you, but they're going to want to make that relationship successful. And they'll love working with you a lot more the more that you can be responsive and realize that what's happening to you is not our fault, and we're here to try to help you through it, but we can't control the other party. So what can you do to make the relationship go smoothly and to keep your costs down? Client cooperation, really, really important. Provide documentation. If you're asked to provide it, we're not asking for it because We really just like want to make you provide financials over and over again. We're asking for it because if you're going to go to court and you're going to ask for financial relief for something, you're going to need to provide current financials. And maybe you provided financials a few months ago, but if we're going to court now, you're going to need to supplement those financials. So don't fight about it. Like if an attorney's asking you for something, it's not just to be asking you for it. It's because they actually need it. And the sooner that you get it, the sooner that they can help you. So provide documentation that you are asked for. Don't fight with us because we're actually on your side. You might not feel like that, but we're on your side. Like and sometimes if I'm telling a client, hey, you can't do that, it's not because I don't want you to get what you want. It's because I don't want to tell you that you can do something you can't do and have you spend money on something that's not helpful for you. So provide documentation, follow your legal advice. The worst is when a client is paying you for legal advice and they aren't taking it. So you get to make the decisions in your case. It's like this. So let's say we're on this side of Puget Sound and we need to get to the other side and we're in a boat, okay? And the water, it's a windy day and there's a bunch of other boats out there. So I'm going to be the captain and I'm going to tell you, this is my strategy to get to the other side. This is how I think we can do it most cost effectively. And this is the best way to go. But you could be like, I don't want to go that way. I want to go this crazy way and go all over here and take all these risks because it's going to be more fun or it's going to make that person mad that I'm going to go around. Fine. You get to make the decision on which way we go. If it's that kind of a decision, we get to make the recommendation. There are other decisions on strategy that are legal decisions that an attorney gets to make that you don't get to make. And you can't just say, oh, I want you to file this and say all these crazy things that aren't true, because if we know they're not true or there's no legal basis for a motion, we have an ethical obligation under Civil Rule 11 not to do that. So you get to make the substantive decisions. Like you get to say, I want to settle on 50-50 property division, even if I know I could do better. I want to settle on that. Great. I might tell you, hey, we should really be pushing for 5% more, or we should really be pushing for that. But you get to make the decision. I made the recommendation. It's just a recommendation. I've given you legal advice, though. Somebody might say, I want to settle for 50-50 and be done, and they should be getting more like 60-40, and they're giving up a $500,000. Okay, I'm going to write down that I told you what to do, but follow my advice because I'm not here to hurt you. I'm here to help you. So it's very frustrating sometimes when you're paying somebody and you're not listening. And that doesn't mean you have to agree with everything, but when we're doing something, know that it's in your best interest. It's not to try to hurt you, it's to try to help you. And if you're working with an attorney that you don't trust, then work with a different one. Because if you don't trust somebody's advice, you're not in a good position and that's not helping you either. So don't do that. You're not alone in this, right? It's difficult. So you need to know that you have a partner throughout the process if you're working with someone else. Like that's what that person is there for. It's your partner in the legal process, just like a therapist is your partner in the emotional side of it. You're not alone. And I sat in a room last night with a bunch of other people who are going through what you're going through. And I do that all the time. And there are countless people that are dealing with these kinds of situations. And this might sound, this is not a knock on anyone. As someone who's been divorced, I can say this too. People make bad relationship choices. Really smart people make relationship choices that maybe are not the best long term. They seem good at the time, but you don't know how this person's going to be in every situation. You don't know what might happen in the future. And maybe it wasn't the best relationship choice, but you didn't really think it through, or you did think it was going to be different, right? And so really smart people, really good people end up in situations that are really negative partnerships for them. And there's nothing wrong with ending those partnerships. And there's nothing wrong with going through struggle. There's no shame in any of it. And it doesn't mean that you did anything wrong at all. And a lot of people are dealing with it. So you're not alone. I mean, that's the best thing I can say because it's literally true. Again, to just keep in mind that attorney involvement, a lot of people are like, oh, we had to get attorneys involved and it was that made everything, so stressful. Well, in a high conflict situation, it's worse when you don't have one because like I said, an attorney should be a guide and like a shield to be dealing with this for you and with you. You have to be a partner in it, but that's different than you having to answer every email, than you having to figure out how to deal with it on your own. And you also can say, I don't want to have contact with that person about the divorce because I have a representative. So those are things for you to know. Ways to deal with situations without litigation can be negotiation through counsel, mediation or arbitration. Mediation too in high conflict cases is worth saying is not everybody sitting around a table, or in any case really, and having a chat about how to resolve issues, because you don't have any privacy there. You don't have a way to get legal advice there in front of the other person, and you don't have to see the other person. Mediation is very much you and your attorney in one room. It's called shuttle mediation. Them and their attorney in the other room. That can be Zoom room, it can be in person, and then a neutral attorney mediator shuttling back and forth between the two sides, giving you an evaluation of your situation. You're able to evaluate offers, things like that. So that kind of shuttle mediation solves very, very, very high conflict cases most of the time. I've had cases that have gone on that have been really high conflict, and they've all settled in mediation. The case I mentioned earlier that's been going on since 2017, that's been a divorce, multiple parenting plan modifications. We've gone to court a lot. We've never actually gone to a trial, because every time there's been a new action, we've actually resolved it in mediation. And these people literally hate each other. So, but with a good mediator, anything is possible. That's one thing for you to know. Neutral professionals, people like financial experts, parenting coordinators, guardian ad litems, they're able to give neutral perspective that is important for the court. It's important in preparing for mediation. It's important for, whether it's a hearing or a trial. So use of neutral professionals can also be very helpful in getting things settled. Before I wrap up and see if there's any final questions, I'll just say that empathy is really important. So you want to work with an attorney that tries to have empathy for your situation, and you want to also be kind to yourself. So you want your friends and family members to be kind to you, but also be real with you. There's a good balance there. And you want to be kind to yourself, like take care of yourself during the process, because it's really freaking difficult. And like I said, there is no shortcut. It's a marathon, it's not a sprint. Everybody wants to rip off a Band-Aid and say, I want this done now. And that's probably true, but that result is usually not the best result and might not even be an option. It's going to take longer than you want, but you're going to get there and you're going to be okay. A bunch of people are okay all the time, and you will be too. Again, key principles in dealing with a high conflict case: structure of how you're going to structure what's happening and understanding that, the strategy behind it and what you can do, and making sure you have support. So structure, strategy, and support. Try to be fair, firm, and friendly. Employ BIF tactics: brief, informative, fair, and friendly. And frankly, at this point, go forward, think about your situation, and reach out if you need support. So I hope that this was helpful. Melissa, do you want me to take any questions before I wrap up?
I think we have done pretty well to cover it. Somebody's asking actually if there are any support groups we recommend for high conflict divorce. And I don't know of any right off the top of my head right now, but keep coming to these. And I think we'll probably do another high conflict seminar at some point in the near future. Come to
Yeah,
our meetup groups. It's not the same. I think I actually led a divorce for women therapy group last year and really enjoyed that. So maybe I'll look at doing another one. And there are others out there. A lot of them are online. So I don't know of any right off the top of my head, but I'll definitely keep folks in the loop if I hear more.
definitely. And just so you know, Melissa mentioned our meetup. We do have a meetup. It has a great panel. And we've been doing it 7 or 8 years now. It's been a while. And we started doing it before COVID, and it was always in person then. And we just did in person last night, which was really fun. I say fun, it might not have been fun for people to come and talk about their problems, but I think it was fun because people felt a lot of support. And we do in person like once a quarter now. And the ones that are not in person, they're on Zoom. It's different on Zoom. You just come and ask questions. In person, it's more of like a dialogue. But we do those, it's free. And if you come to our meetup in Bellevue when we have them, there's free food, and you can kind of socialize with other people and see that you're literally not alone. So yeah, like Melissa said, continue to, tune in if you want this content. There's probably other resources out there. There's just not like a lot by way of support groups right now. So I don't really know why. I think it's interesting because before COVID, there was a lot more that I could say, oh, this group always meets here or whatever. That kind of stopped. And now, it seems like some more might have come back online, but yeah. So anyway,
Absolutely.
I hope that was helpful. It was really great to have you here. You guys had a lot of really good questions. Hope it was helpful to you. And thanks for coming. So have a lovely day. Take care. Bye-bye.
Thanks, everyone. I'll leave this contact slide up here for just another moment in case you'd like to contact us. Please contact Michelle's firm. There's a great intake team that can chat with you on the phone and get you set up with a consultation. If anyone's interested in counseling services, please don't hesitate to reach out to me. And yeah, we look forward to seeing you again on one of our events. Take care.